Good morning, all. I'm Dwight Keene. I'm chair of the Kansas Corporation Commission. I'm joined this morning by fellow commissioners Susan Duffy and Commissioner Andrew French. I'm convening this hearing on Tuesday, September 27, 2022 at 9 a.m. via Zoom on the settlement agreement in the matter of the application of Atmos Energy Corporation for the recovery of qualified extraordinary costs and the issuance of a financing order pursuant to and under docket number 22-ATMG-538-TAR. We are conducting this hearing via Zoom and broadcasting to the public on YouTube. Please bear with us if you experience any technical glitches. Let's begin this morning with the entries of appearance. I'll turn first for Atmos and Mr. Flaherty.
Good morning, Your Honor. James G. Flaherty, Ottawa, Kansas, and Kevin Frank, appearing on behalf of the applicant, Atmos Energy Corporation.
Thank you, Jim. Curb, Mr. Astrad.
Yes, this is Todd Love. I'll be entering the appearances. Joseph Astrab appearing on behalf of Curb and Todd Love on behalf of Curb.
All right, thank you, Todd. The KCC staff, Ms. Mazantine.
Good morning. This is Michael Neely on behalf of staff. We have quite a few attorneys. We have myself, Carly Mazantine, Walker Hendricks, Ed Watson, Harvey Sorensen, and Sarah Buchanan, all on behalf of staff.
All right, thank you very much, Michael. Does the staff have a recommendation regarding notice?
Yes, we do. On June 23rd, 2022, the Commission issued an order setting procedural schedule, establishing a hearing in this matter for September 27th through the 29th, beginning at 9 a.m. On September 20th, 2022, the presiding officer amended the schedule via order to convert the hearing to a one-day hearing on the proposed settlement agreement, starting at 9 a.m. or 9:30 a.m. on September 27th, 2022. The service list for these orders indicates that all parties to the proceeding were properly served. Therefore, staff recommends a finding of proper notice for this hearing.
All right, very well. Are there any objections to notice? Hearing none, I find that notice is proper and that the commissioner has jurisdiction over this proceeding at this time and place. Before we turn to preliminary matters, let's review a few matters incidental to conducting a hearing via Zoom. First, if any party encounters any technical difficulties today, please ask you to go off the record so that we may resolve the technical issues off the record. Second, all witnesses participating by Zoom are asked to keep their microphones off until they are scheduled to speak. Third, if the commission needs to deliberate, we will go off the record, enter a Zoom breakout room, where you cannot see or hear us, and then subsequently return. Do any parties wish to admit pre-filed testimony into the record at this time?
Yes, Mr. Chairman. Atmos Energy would like to move for the admission of Jason L. Snyder's direct testimony, which was filed in this docket on May 26, 2022. Also his exhibit JLS-1 and JLS-3 that were filed on July 25th, 2022, and his revised direct testimony, which was also filed on July 25th, 2022.
All right, very well. Is there any objection? Without objection, all of those are admitted. Any further requests for admission of pre-filed at this time?
Staff will move.
Yes, go ahead, Mike.
We'll go ahead and move for the pre-filed direct testimony of Justin Grady, which was filed on August 26, 2022, and the testimony in support of the unanimous settlement agreement of Justin Grady, filed September 19th, 2022.
All right. Is there any objection? Without objection, they're admitted. Any other preliminary matters we need to address?
Commissioner Keene, this is Todd Love. Since we're doing pre-filed testimony, Curb would ask for admission of the pre-filed direct testimony of Josh Franz and his pre-filed testimony in support of the settlement agreement. He will be here to testify as well, but if we're going to go ahead and do these as a point to take care of it.
Very well. Thank you, Todd. Is there any objection? Without objection, it's admitted. One last call. Any other preliminary matters we need to address? Seeing none, very well, let's discuss the procedure for this hearing. The parties will make opening statements. Atmos will go first, followed by Curb, and then the KCC staff. After opening statements, we will follow the order of witnesses agreed to in the pre-hearing conference. I also understand that at the pre-hearing conference, the parties indicated that they will not make closing statements, and that we also have a procedural schedule that at least presently allows for post-hearing briefs. Let's turn now to the opening statements. I'll turn first for Atmos to Mr. Flaherty.
Thank you, Honor. Good morning, Commissioners. The parties are here to present to the Commission for its consideration and approval a unanimous settlement regarding Atmos Energy's request to issue securitization bonds. The proceeds from those bonds will be used to finance the extraordinary cost incurred by Atmos Energy during Storm Uri, which occurred back in February of 2021. Use of the bonds will allow Atmos Energy to reasonably mitigate the rate impact to Atmos Energy's customers. What I'd like to do in this opening statement is to first identify and briefly discuss the benefits customers will receive if the settlement is approved in this case. And then I would then like to briefly walk through the main terms of the settlement. Ms. Kathleen O'Connor, who is the Vice President of Rates and Regulatory Affairs for the Colorado-Kansas Division of Atmos Energy, and who participated in the discussions that led to the settlement being presented to the Commission, is presenting testimony in support of the settlement, and she will be available to answer your questions. If you recall, Ms. O'Connor testified on behalf of Atmos Energy in the 21-333 docket, where the Commission approved Atmos Energy's financial plan relating to Storm Uri, which precipitated the filing of this current docket. Let's first talk about the benefits that customers will see as a result of the settlement. By the parties to this settlement being able to take advantage of basically two things: the Kansas legislature's Utility Financing and Securitization Act of 2021, and this Commission's order in the 21-333 docket that approved Atmos Energy's financial plan to apply for authority to issue securitization bonds under the Utility Financing and Securitization Act. They were able to craft a settlement in this docket that results in two very significant benefits for Atmos Energy's customers. You are aware, with your involvement in the other utility dockets dealing with the recovery of Storm Uri costs, that absent at Atmos Energy's ability to take advantage of the Securitization Act and this Commission's order in that 21-333 docket, the nearly $100 million in extraordinary costs incurred by Atmos Energy in the February 2021 Storm Uri, which has been deferred now, going on 20 months for future recovery from customers. Atmos Energy would have had to use basically a traditional rate-making method to recover those costs from customers. Likely that would have been the PGA ACA process that would have required a much shorter recovery period, probably between 3 to 5 years, and at a relatively higher carrying charge rate. Such would have resulted in a higher monthly impact to customers and a lower net quantifiable present value rate benefit to customers. By Atmos Energy being authorized to issue securitization bonds as proposed under the settlement before you today, it can extend the recovery period over 10 years at a relatively lower carrying charge rate. This results in the first benefit for Atmos Energy's customers, which is a mitigation of the monthly impact on customers. Approval of the settlement will allow for a reduction in the monthly impact to the residential customer by about $5 per month. If the settlement is approved, the residential monthly rate would be reduced from approximately $10.55 per month had we had to use a traditional rate making method, and reduced to approximately $5.78 per month. The second benefit is that the settlement and the issuance of the securitization bonds under the settlement will result in a net quantified present value rate benefit to the customers of about $8.5 million when compared to recovering the qualified extraordinary costs using traditional rate making methods. And the witnesses in today's hearing can explain how that benefit was calculated. With respect to the terms of the settlement, it is important to point out that the terms in this settlement are nearly identical to the terms contained in the settlement that this commission recently approved in authorizing Kansas Gas Service to issue securitization bonds to recover its Storm Uri cost. Let me just run through the main terms of the settlement with you. Paragraph 10 of the settlement identifies the estimated qualified extraordinary costs to be recovered through the issuance of securitization bonds. The total is estimated at $118.5 million, with the expected principal amount being $92.6 million. The final amount will be provided to the commission as part of the final issuance advice letter process that was established by the Securitization Act and set forth in the proposed financing order. Paragraph 11 of the settlement identifies the net quantified rate benefits to customers as $8.5 million based upon a 10-year securitization and the most recent estimates of securitized bond interest rates for 10 years, as compared to recovering the qualified extraordinary costs using traditional rate making methods, basically using a 5-year amortization period and the utility's weighted cost of capital to calculate the carrying charges during that amortization period. Paragraph 12 of the settlement sets forth the pre-issuance review process and the role of the commission's designated representative and its consultants. This process, as you'll see, is identical to what was agreed to in the KGS securitization bond settlement and approved by the commission in that docket. Paragraph 13 of the settlement sets forth the term length of the bonds. It is expected that the term of the bonds will be 10 years, although the length of the bonds can be modified to a maximum of 12 years in consultation and subject to review by the commission's designated representative. Paragraph 14 of the settlement requests that the commission approve the proposed financing order that is attached to the settlement. The proposed financing order approves the securitization process and covers all of the requirements contained in the Securitization Act. It is also nearly identical to the financing order this commission approved recently in the KGS docket. Paragraph 15 of the settlement requests that the commission approve the transaction documents that are attached to the proposed financing order as to form, and those will be subject to any changes that may need to be made during the securitization process, and that those will be subject to review by the commission's designated representative. Paragraph 16 of the settlement requests approval of the winter event securitized cost recovery rider tariff and discusses the provisions contained in the tariff. This tariff is also nearly identical to the tariff the commission approved in the KGS docket. Paragraph 17 of the settlement sets forth the settlement fee to be charged to any sales customers that wish to switch to transportation service during the term of the tariff. Paragraph 18 of the settlement requests approval of the reconciliation process that is set forth in Ms. O'Connor's testimony as modified by the settlement. The final amount of the qualified extraordinary cost will be compared to the final amount of the securitized bond issuance, and the difference will be credited or charged to customers through the PGA process. Paragraph 18 also sets forth a process to credit customers if the incremental cost of Atmos Energy to perform its services under the servicing and administrative agreements are less than what Atmos Energy is paid to perform such services. Paragraph 19 addresses the treatment of investment earnings on the capital subaccount, and those are identical to what this commission approved in the KGS docket. Paragraph 20 requires Atmos Energy to work with staff and CURB to finalize and implement the program to educate customers about the benefits of the securitization bond process, which is required under the Securitization Act. Paragraph 21 of the settlement allows Atmos Energy to waive its rules and regulations in order to allow the payment of securitized bonds to take priority over the rest of the customer bill in the event of a partial customer payment. This term, along with a few of others included in the settlement, will support the highest bond ratings and therefore the lowest ultimate cost to customers. Paragraph 3 of the settlement provides for Atmos Energy staff and CURB to work with the commission on an investigation into attempting to quantify the energy burden in Kansas and what steps might be available to address the burden, especially for low-income customers. As I indicated previously, Ms. O'Connor will be providing testimony in support of the settlement and will address any questions regarding the settlement. Finally, in case I don't get a chance at the end of the hearing to do so, Atmos Energy wants to state on the record its appreciation for the collaboration efforts made by staff, including staff's outside consultant and counsel, and CURB in this matter. The technical and settlement conferences conducted during this docket were of a tremendous benefit in ultimately achieving the financing order and process that will result in the issuance of securitization bonds that will allow for recovery of Storm Uri cost and the reasonable mitigation of the monthly rate impact that such recovery will have on Atmos Energy's customers. Atmos Energy would request that the commission approve the settlement being presented this morning and to issue the financing order that will allow for the issuance of securitization bonds to pay for the cost incurred during Storm Uri. Thank you.
Thank you, Jim. Next opening statement will be on behalf of CURB. Mr. Astrab.
Thank you. My name is Joseph Astrab, and I, along with attorney Todd Love, are here to represent the Citizens Utility Ratepayer Board, otherwise known as CURB. Our mission at CURB is to advocate for the interest of residential and small commercial ratepayers in proceedings before the Kansas Corporation Commission. The docket today is a continuation of docket number 21-ATMG-333-GIG, in which the commission approved Atmos Energy's proposal to recover prudently incurred extraordinary expenses from the 2021 winter event. Through our witness, Josh France, CURB will ask that the commission approve the unanimous settlement agreement regarding the application to issue customer-backed bonds through a process called securitization. Mr. France filed pre-written testimony in favor of this agreement and is present to answer questions regarding CURB's position. His recommendation to approve the agreement is based on his analysis of the three factors that the commission uses to review unanimous settlement agreements. Is the agreement supported by substantial competent evidence? Will the agreement result in just and reasonable rates? And whether the agreement is in the public interest. In particular, CURB is mindful of the overall bill impact on customers and the importance of efficient and reliable services, especially during emergency situations. Mr. France examined these factors from the perspective of residential and small commercial ratepayers and concludes that the agreement satisfies all three factors. First, substantial competent evidence supports the agreement. In his testimony, Mr. France refers back to the work done in docket number 22-KGSG-466-TAR, in which the commission approved the plan to issue securitized bonds for Kansas Gas Service's extraordinary winter event costs. In essence, that docket provided a blueprint for parties here to develop a financing order to support the issuance of these bonds. The record here contains testimony from all parties that describe the considerations of bond rates and a myriad of factors that drive the current decision to move forward with securitization versus traditional rate-making methods. Further, the agreement will result in just and reasonable rates because bill impacts will be smaller through securitization than if Atmos recovered the cost through other means. Kansas Utilities' efforts to maintain service during the winter event likely avoided an even larger disaster beyond the current financial situation. While the agreement does not directly set rates, the plan to issue bonds will make the company whole for its efforts without imposing too high a burden on ratepayers. Current estimates for the monthly bill impacts on residential customers are approximately $5.96 per month with a 10-year final maturity date. In contrast, traditional rate making would result in a nearly $11 per month increase for 5 years. While CURB understands that bill increases are rarely welcomed by customers and can disproportionately impact low-income residents, CURB believes that the estimated charge will be more manageable than a shorter recovery period at a higher interest rate. Parties also agreed to work together in order to study energy burden in Kansas and develop tariffs that can provide these vulnerable customers some form of relief pending appropriate legislative action. Implementing low-income tariffs in Kansas is an important goal to CURB, and this provision in the agreement is a step in that direction. However, CURB did relent on another position in this agreement, the use of volumetric versus fixed pricing. CURB advocates for the use of volumetric pricing in rate cases to give customers more control over their bills and to promote conservation efforts. It is a position shared by CURB's board members and the values that each member holds. However, this docket presented unique considerations that caused CURB to depart from that stance, albeit non-unanimously from our board. Securitization benefits stem from the ability to achieve the lowest possible rates through the highest possible bond ratings. A volumetric charge would allow customers to reduce their personal bill impact through conservation efforts. However, the uncertainty of collection levels associated with such pricing would jeopardize the bond's ability to obtain the highest possible rating. As a result, customers could lose out on the net benefits attributed to securitization, and it might even prevent the issuance of the bonds altogether. This possibility convinced the majority of our board to support the agreement. However, CURB retains its ability to advocate for volumetric pricing and other rate-making aspects. Finally, from CURB's perspective, the agreement is in the public interest. All three parties have joined together in this agreement, representing a wide range of interests. CURB supported recovery of costs in the 21333 docket and believes that making the utility whole is important to ensuring that Kansas utilities once again rise to the occasion during emergency conditions. Again, while no customer enjoys bill increases, it is clear to CURB that all tools should be considered to account for such a historic situation. Securitization will minimize the impacts on bills while providing recovery to the utility at a pace that will maintain its financial integrity. Furthermore, the inclusion of the commitment to working towards low-income rates and energy burden will benefit all ratepayers on some level. After the presentation of evidence, CURB asks that the Commission approve the unanimous settlement agreement as presented. Thank you.
Thank you, Mr. Astrad. Next opening statement will be on behalf of KCC staff, Mr. Neely.
Good morning. Thank you, Commissioners. The staff supports the settlement agreement in this matter, which allows Atmos to issue securitized utility tariff bonds to recover the extraordinary costs incurred due to the February 2021 Winter Storm Uri. The terms of the settlement agreement authorize Atmos to recover roughly $118 million in qualified extraordinary costs through fixed monthly charges on customer bills. Staff's witness, Justin Grady, will testify to the terms of the settlement agreement and, in general, explain why adoption would lead to just and reasonable rates. At a high level, benefits of utilizing securitized utility tariff bonds as opposed to traditional rate-making methods is estimated to be $8.5 million for a 10-year securitization. Staff will also explain the changes made to Atmos's proposed financing order to adopt a collaborative pre-issuance review process in order to achieve the highest possible bond ratings, as well as achieve the lowest securitized utility tariff charges pursuant to the Kansas Securitization Act. There are other matters covered under the settlement agreement, including approval of certain transaction documents as to form, the tariff and true-up mechanisms that will be used, the reconciliation process that will utilize the purchase gas adjustment clause, the treatment of investment earnings on the capital subaccount, the customer education program, a waiver of any rules and regulations to allow payment of securitized bonds to take priority over the rest of the customer bill, and a commitment to study low-income relief programs in the event of a legislative change authorizing the commission to enact such programs. Staff will also explain why the settlement agreement in this matter meets all of the elements the commission usually considers in determining whether to grant approval. At the close of the evidence, staff would ask the commission approve the settlement agreement in this matter. Thank you.
Thank you, Mr. Neely. That concludes the opening statements. We will now turn to the examination of witnesses. I'll turn first to you, Mr. Flaherty, if you would please call your witness.
Yes, thank you, Your Honor. Atmos Energy would call Kathleen O'Connor.
Please raise your right hand. You do solemnly swear the testimony you're about to give and the matter now in hearing will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
State your name and business address.
My name is Kathleen O'Connor. That's OCANAS. My business address is 25090 West 110th Terrace. That's in Olathe, Kansas, 66061.
Who is your employer?
Atmos Energy Corporation.
What is your position with Atmos Energy?
I am the Vice President of Rates and Regulatory for our Colorado and Kansas division.
In that capacity, did you file direct, revised, and rebuttal testimony in this docket?
Yes, I did.
And did you also file testimony in support of the settlement in this docket?
Yes,
Do you have any changes to any of that testimony?
I do not.
If I were to ask you the questions that appear in your testimony, would your answers be the same?
Yes, they would.
Your Honor, I'd ask for the admission of Ms. O'Connor's direct, revised rebuttal testimony and also her testimony in support of the settlement.
Is there any objection? Without objection, they're admitted.
Thank you. And I would tender Ms. O'Connor for commission questions.
Very good. Thank you very much. Good morning, Ms. O'Connor.
Good morning.
Let's turn to the commissioners and see if we have any questions for you on cross. I'll turn first to Commissioner Duffy.
Good morning, Ms. O'Connor. I appreciate you being here today.
Thank you. Good morning.
So I would like to start out stating that time is of the essence in reviewing and approving the settlement agreement. We live in a changing world in terms of the economy, and I note in your revised direct testimony on July 25th, I'm looking at page 4, beginning with line 12. The question is, does recovery of Atmos Energy's extraordinary costs through a securitized utility tariff charge provide quantifiable benefits for customers? Your answer is yes. So that was July 25th. Today is September 27th. Is your answer still yes?
Yes, ma'am, it is. We have seen that just based on, our opening comments that, we are still seeing the net quantifiable benefits per customer of approximately $8.5 million.
Okay. And do you anticipate that will change substantially during the time of today and when those bonds are actually in place?
No, I don't. Obviously, as you stated, time is of the essence. Interest rates are changing. We do anticipate some change, but substantial is, I would not say.
Okay. I'm going to reinforce this because as I read Mr. Schneider's testimony, he talked about how bonds provide rate certainty. And again, looking at the JP Morgan chart that was submitted once in May and again in July in testimony, it appears that interest rates have gone up. So your answer again concerning the value to the customer is a solid yes?
Yes, ma'am. We continue to believe that securitization will provide the most benefit to the customers versus traditional rate making.
Okay, thank you. One last question for me. There was discussion, and it's in the settlement agreement, that the entities are working towards a low income rate. Does your company support the application of a low income rate if that is approved by the legislature?
Yes, I would say that we would. We have in several of our states energy assistance program with a low income component to that, and so we are very interested in working with staff and CURB on addressing that issue.
Will you work this year in the 2023 legislative session to accomplish that?
Well, I know CURB is currently working on some legislation, and we're definitely interested on seeing what they proposed. But yes, definitely that is something we're interested in.
Okay, thank you. I appreciate it. Thank you, Chair Keen. That's the extent of my questions.
Thank you, Commissioner Duffy. Commissioner French.
I have no questions. Thank you.
Thank you. Two of the questions I was going to ask, Commissioner Duffy has asked. So I have no further questions either. I would turn to you, Mr. Flaherty. Do you have any redirect?
No redirect. Thank you, Your Honor.
All right, very well. Well, so Shaughnessy, your testimony is at an end, I believe. We appreciate very much your appearing before us this morning, and you're virtually excused.
Thank you.
Thank you. All right, we'll turn next to a CURB witness. Mr. Astrab, if you would, please call your witness.
And Commissioner King, this is Todd Love. I'll be handling this part of it. We would call Josh Franz to the stand.
Please
I'm
raise your
fine,
right
Don. Thanks.
You do solemnly swear the testimony you're about to give and the matter now in hearing will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, ma'am.
Thank you.
Could you please state your name for the commission?
Yes, my name is Joshua Franz. I go by Josh, and my last name is spelled Frantz.
And for whom are you employed?
I'm employed by the Citizens Utility Ratepayer Board, commonly known as CURB.
What is the address of CURB?
1500 Southwest Arrowhead Road, Topeka, Kansas, 66604.
Are you the same Josh Franz that Cosby filed 12 pages of testimony? Oh, excuse me, 23 pages of direct testimony dated August 26th of 2022?
Yes, correct.
Are you the same Josh Franz Cosby filed 12 pages of testimony in support of the settlement agreement on September 19th of 2022?
Correct. Yes.
Do you have any changes you'd like to make to your testimony?
No, I do not.
If I were to ask you the same questions today, would your answers be the same or substantially similar to those you already have given?
Yes, I agree.
Commissioners, at this point, I'd move the direct testimony and testimony in support of the settlement agreement of Josh Franz be admitted and spread upon the record.
We
During the objection.
already admitted during the preliminary matter phase.
I'm sorry. We have indeed. We did that prefatory, certainly to the questions that Mr. Love has asked of the witness. Given the motion that's before us, thank you. I appreciate that, Brian. Given the motion that's before us, is there any objection at this time? Without objection, it's certainly admitted or readmitted.
Thank you, Commissioner. At this point, I would tender Mr. Franz for commission questions.
All right, thank you very much. Good morning, Mr. Franz.
Good morning.
Let's see if you have any questions from commissioners. I'll begin this time with Commissioner French.
I have no questions for Mr. Franz. Thank you.
Thank you. Commissioner Duffy.
Good morning. Yes, thank you, Chair Keen. I do have questions. Mr. Franz, there you are on my screen, trying to find you. On page 14 of the direct testimony that you have offered, I'm looking at line 14. It states CURB still believes, and this is dated 8/26, that presently financing the QEC through securitized bonds rather than traditional rate-making methods would yield substantial savings for customers. Mr. France, do you believe that is still true a month later? And also, do you believe it's still to be true at the time that the securitized bonds are actually put into place?
I do believe that it is true currently. My understanding is that there was, I think, some revised or updated documents filed right before the hearing, like maybe last week, that had a slightly higher interest rate, but still showed substantial savings. And so I'm still convinced that this is the right way to go. And also, aside from the interest rate, I think a big piece to me is that the time frame. So securitization gives customers 10 years, which I think is the right amount of time. And under traditional rate making, you're looking at probably max of 5. And so that's another piece that I think it really helps with the net present value of the benefits.
And these are the benefits to the entities that you regulate, which are, it was stated that you advocate for residents and small businesses.
Yeah, that's correct.
Okay, thank you. I have a second question, if you would, Mr. France. On page 17 of your direct testimony, you also reference that CURB, and I'm reading, CURB has been working with several utilities on this issue, and this is the low income rate, and is hopeful that legislation can be proposed during the next legislative session. CURB desires to work with Atmos and other utilities to develop a low income tariff. My question to you is, will you be working with these entities during this upcoming legislative session?
Yes, we will. We've already started. We do have draft legislation put together. We worked on that initially. This is no offense to Atmos, right? But we're trying to kind of, what's the old adage of too many cooks in the kitchen, right? So we started with KGS, and we've come up with some language. We've I think last week we ran it by KCC staff members, and we're waiting for some feedback from them. We certainly, before the start of the legislative session, plan to get input from all utilities, including Atmos. I believe we've reached out and informed Atmos that we have some language ready, and they're just sort of, they're aware that we're working through things, and we'll be getting to them, real soon. Certainly, hope in the next couple months before the legislative session really gets in full swing.
And as Ms. O'Connor stated earlier, that Atmos offers a low income rate in other states. Do you believe that, or do you have knowledge that the gas companies have the ability to, on a bill, charge a low income rate?
I think that currently that is up for question. I know there are some concerns, particularly on KCC staff's end, about relates to I think it's a Supreme Court case, a Jones case, but basically has to do with discrimination, discriminatory rates. And so basically what we're trying to put together now is a legislation that says, you can have a rate for low income customers that's essentially subsidized by other residential customers. And that on its own is not unduly discriminatory. And so that's really all we're trying to take the question out of the equation here is whether or not you can even have any sort of cross subsidization between among residential customers. And so what we're working on would be open, permissive. So with the legislation, what we're working on would allow utilities to implement low income rates, but it wouldn't put any parameters on what that would have to look like necessarily, and it would not require them to offer, but it would at least open the door and make it a possibility, which we believe just the mere sort of concept right now is sort of, I guess, challenged in some aspects. And so we're just trying to take that piece of the get rid of that obstacle essentially.
Okay, thank you. That's a lot of information you just shared. Finally, my last question on page 20, again, of your direct testimony, you discussed that CURB will collaborate with stakeholders to develop a strategy to inform and educate customers about the Westcar charge that would appear on the bills. So are you actively engaged with the company to be able to inform them of this potential charge that will appear, presumably almost 2 years after Storm Uri?
With Atmos, we have not been yet, but with other companies, we have been. Like with KGS, we've had meetings, and with Evergy, I know we've had some meetings discussing how they're going to get the message out there. The best way to inform customers without, there's a fine line between informing customers and causing sort of a panic about a bill increase. So we're sort of, working through the sort of nuances of the best way to get that message out there and help inform customers. So we're definitely taking an active role in meeting with the utilities ahead of the, I guess, the promotional or advertising sort of messages that they're getting out there.
Okay, thank you. Thank you, Chair King. That concludes my questions.
Thank you, Commissioner Duffy. Mr. France, I have no questions of you. Mr. Ace, do you have any redirect?
We have no redirect.
All right, very well. Mr. France, I believe that concludes your testimony. We appreciate your appearance before the commission this morning, and you may virtually step down.
Thank you.
Final witness for us this morning is for the KCC staff. Mr. Neely, if you would, please call your witness.
Yes, staff would call Justin Grady.
Good morning.
Please raise your right hand. You do solemnly swear the testimony you're about to give in the matter now in hearing will be the truth, the whole truth, and nothing but the truth, so help you God.
Do.
Thank you.
Good morning. Please state your name and business address for the record.
My name is Justin T. Grady, and my business address is 1500 Southwest Arrowhead Road, Topeka, Kansas, 66604.
By whom and in what capacity are you employed?
I'm employed by the Kansas Corporation Commission in the Utilities Division, and my title is Chief of Revenue Requirements, Cost of Service, and Finance.
Are you the same Justin Grady that pre-filed direct testimony on August 26, 2022, and testimony in support of the unanimous settlement agreement on September 19th, 2022?
I am.
Do you have any changes or corrections to make to either of your pre-filed testimonies?
I do not.
And is all of your pre-filed testimony true and accurate to the best of your knowledge?
It is.
Since Mr. Grady's testimony was already admitted as a preliminary matter, we would go ahead and tender him for cross.
Thank you, Mr. Neely. Good morning, Justin.
Morning.
Let's turn to the commission and see if we have any questions for you. I'll begin first with Commissioner Duffy.
Good morning, Justin.
Good morning, Commissioner.
So I've had kind of a theme going here, and it has to do with you filed your testimony on August 26th. It is now September 27th. Do you still believe that the issuance of securitized bonds is the correct and best way to go in terms of paying the costs of Storm Uri for Atmos customers?
Yes, at this point I do. Yeah, I can elaborate a little if you'd like.
Please do.
Okay. So, it's interest rates, the path of interest rates during the course of this docket have been not always straight up, right? So it was when I put together my testimony, I actually referred to the fact that interest rates had declined some since Mr. Schneider had filed his rebuttal. But so, the question I asked was, have interest rates increased, steadily over the last several months? And my answer was, well, not really, but they've been very volatile. Of course, since that date that I filed that testimony, it has been almost a straight up trajectory. So we are looking at, quite higher treasury rates today in that portion of the yield curve that is going to most affect these bonds, which would be, between 7, 10 to 12 years or 15 years. So, Mr. France alluded to the fact that the company provided an updated view of their view of the world that was dated like a week ago, right before this hearing. And that was sort of a refresh for all of us to say, here's where we stand today in terms of treasury rates and what that means for net quantifiable benefits and what that means for anticipated monthly bill impact. The net quantifiable benefit calculation is really just a precise calculation of the net present value to customers at time zero associated with a series of cash flows or bill outflows, right? And we're doing that calculation consistently with how we did it in the KGS case. There's no difference of opinion or discrepancy between how the parties view what that calculation looks like. And that was one of the things we nailed down during the technical conferences in this docket. And so everybody knows, exactly how to do the math. And now going forward, as we experience continued volatility in interest rates, what's important is that we ensure that before these bonds actually go to market, that there is still net quantifiable rate benefits. And that's a statutory standard. So it's not like it's something that we will, compromise on or ignore. It's critically important. And then, the final calculations of net quantifiable rate benefits will be presented in the issuance advice letter. And these bonds won't go to market unless there is true net present value benefit. One other quick thing, and Mr. France alluded to this as well, is, what I've come to sort of realize through this process and through my involvement as the designated representative in the KGS issuance is that, the spreads on these securitization bonds, in other words, what you have to pay over treasury rates, has expanded quite significantly in 2022 compared to, say, 2021's securitizations. And so you might look at that and say, well, the end rate that you're paying is 4 or 5%. Why is this still a good deal for customers? And what it really comes down to, and Mr. France hit the nail on the head, is that this financing tool, takes the financing for these extraordinary costs completely off the utilities books. And so it allows it to be 100% debt financed over a much longer period of time than you would otherwise be able to finance these costs. And so, you don't want to, obviously it's a balance, right? If you could securitize these over 20 or 25 or 30 years and shrink that monthly payment down, but nobody wants to pay $3 for 30 years as opposed to $5 for 10 years, right? So, but what I looked at this morning is I took that more recently refreshed net quantifiable rate benefit data from a week ago, and I added another full 100 basis point increase on the 10-year treasury note, just saying, we're several months between now and when we issue these bonds. What if this happens? And you still see a net quantifiable rate benefit, but it gets tighter, for instance, with the movement in interest rates that we've seen since Mr. Schneider filed his rebuttal testimony, or since I filed my direct, you've seen the net quantifiable rate benefits shrink from, say, 11 or 12 million down to 8 million. And so that's quite a significant percentage, but it's still around 10% of the principal amount of $90 million is the amount of the bonds. That's pretty comparable actually to what we were looking at in the KGS docket. And then what you see in terms of customer bill impacts is, you might see a pretty significant change in that net quantifiable rate benefits, because it's a net present value calculation over a 10 or 12-year period of time. Relatively small changes in the monthly payment over 10 years can make a big difference today in today's dollars. But the monthly customer bill impact number, only changes from $5.75 to, say, $5.96, right? And it's a quite significant change in interest rates, 1.5% change in treasury rates of the underlying financing cost, but it doesn't move the customer bill impact number that much. So that's why I say that, the true benefit of securitization is the ability to stretch that payment out over time without damaging the utility, without requiring the utility to hold up its financing, or to bottle, to restrict its ability to finance other ongoing investments. And otherwise, it takes it completely off the utility's books, allows customers to pay over time, and then it mitigates that per customer bill impact number. And so, but if there's not net quantifiable rate benefits, these bonds won't go to market. That's sort of all there is to it.
And again, we're still looking at approximately 10 years. Is that correct?
Yes. But what we said in the financing order is the goal is 10 years. The maximum is 12 years. And that's just because, part of the process after assuming this financing order is approved is then first thing you do is you go to the rating agencies, you tell them the story, and you try to get a AAA rated bond. And the rating agencies are totally independent, fiercely so. They're going to do all their own modeling and analysis. And it may come out that they say, hey, in terms of the percentage of the bill, you won't get a AAA rating if you do a 10-year issuance, but we will give you one if you do a 12-year issuance. And so that's why the flexibility is important in the financing order, and for this utility in particular. With KGS, their costs per customer were a little less. And so we were looking at 7 to 10 years, but there's unanimous agreement amongst the parties that it doesn't make sense to go to 15 years in this case. And so we're not going to do that. That's why it says a maximum of 12 years, but the goal would still be 10. But, it's weird, right? And the capital markets are, it may be that you get a lower interest rate for a 12-year issuance than you would a 5, a 7, or a 10. And so that's why flexibility is so important. But, if you look at the yield curve today, the federal government is paying people more to borrow money for a 2-year loan today than they are for a 30-year loan, right? So it's just, that you got to be flexible and recognize that in this environment, but still that flexibility is bounded in the financial order, and it's 10 to 12 years.
And you mentioned you are the designated representative, I believe, in this particular docket as it's identified in the settlement agreement. Okay, very good. I do have a question. On page 31 of your testimony, you talk about the profit margin for the ongoing finance costs paid to Atmos as part of its servicing or administration obligation under the securitization, and it will be recorded as a regulatory liability so that it can be credited to customers in the next base rate case. So are we talking about the most recent rate case that's, I believe, been filed, or what are we looking at?
Yeah, it will be the next one.
Not this one.
Not this one. Yeah, because there's not time, basically. I mean, these bonds, it'll be several months before these bonds go to market, right? And that rate case is fully in evaluation as we speak. So
very good. Thank you. Thank you for clarifying that. Also on pages 33 and 34 of your direct testimony, you speak to that you're working with CURB on the communication aspect of this settlement agreement. So you're an active participant in how this will be presented to Atmos customers?
yes.
Okay. Will this be a separate line item that they see each month on their bill? I'm sorry.
I'm not
I
hearing
can't
you.
hear you, Justin. It looks like you've lost some audio. There we go. All right.
Oh, I just said yes, it will.
Okay. All right. Very good. Let me look here. I believe that's all the questions I have. Thank you. Thank you, Chair Keen.
Thank you, Commissioner Duffy. Commissioner French, please.
I don't believe I have any questions. I appreciate all the extra information Mr. Grady provided, walking us through the context and I guess how he's thinking about some of these issues. So I found that very helpful, but have no further questions.
All right, thank you. Commissioner Duffy, did you have something further?
Yeah, I'm sorry. I do have one more. I'm sorry. It was on another sheet of paper. Justin, have you been updated on the Attorney General's investigation of perhaps any malfeasance or nefarious activity as it relates to gas prices in this particular docket? Has staff over there been visiting with you and your staff about the ongoing investigation?
So what I know is that there have been recent communications in terms of requests for additional sharing of information and communication of those sorts. But that was attorney to attorney communication. And but other than that, beyond that, I don't have any other formal updates.
And that was just recently that this information was requested. Okay.
Yeah, the last couple weeks.
Okay, thank you very much. And thank you, Chair Keen.
Indeed. Yes, Justin, I really join with Commissioner French in his view that certainly the responses you gave to Commissioner Duffy in response to her first question were pretty exhaustive, pretty inclusive, and very understandable in terms of casting a holistic overview of where we are here. I just have one other question as we look down the trail here a bit prospectively. Are you anticipating that staff will also be involved in the process of considering maybe some form of legislation to come before the 23 session?
Yes. So, as you know, Chair, we as staff meet internally and have a legislative group. And so we don't take a position one way or the other on proposed legislation without consultation with and direction from the commissioners. So we have been involved in the meeting that Mr. France discussed. It was important for CURB to make sure that we didn't have any concerns with the language, with the technical aspects of the language. And I think the reason perhaps that we haven't provided them a formal response back is because we're waiting on internal communication channels with regard to the legislative group that I discussed. But we don't see ourselves taking an active role, I would say, in that legislation, because it's a policy matter. In our opinion, it's a policy matter of the legislature and the governor, and then the commission will implement that policy as the policymakers of the state decide is appropriate. But whatever position we take, one way or the other, will not occur absent input and direction from the commissioners.
Well, thank you for that overview. I appreciate that very much. I have no further questions for you myself. We'll turn back to you, Mr. Neely. Any redirect?
No redirects. Thank you.
All right, very well. Well, Mr. Grady, I think that concludes your testimony this morning. We appreciate very much your appearance before the commission, and you may step down virtually.
Thank you.
This concludes our hearing in docket number 22-ATMG-528-TAR. As a result of the pre-hearing conference, presently post-hearing briefs are due October 18th, 2022. However, I understand that the parties may wish to waive post-hearing briefs to expedite an order. Counsel, would any of you care to address that?
Yes, Your Honor, this is Jim Flaherty. Yeah, Atmos Energy would request that the parties, and I think all the other parties agree, that we would go ahead and waive briefs and request that the commission expedite the order, given Mr. Grady's testimony with respect to the volatility of the markets. And so to the extent that that would allow the commission to issue an order on an expedited basis, we would make that request.
Very well. The commission, for its, we appreciate this as well. We're sensitive to this. We can see and we can certainly comprehend the time is of the essence here for all parties involved. With respect to this request, what I will commit to you is that we will certainly take administrative notice of this request, and we'll attempt to accommodate the request insofar as it is practical to do so, and I think it probably will be. All right. Final matter here is that the commission order in this docket is due by November 17th, 2022. If there are no further matters, we will adjourn. Before I bid sine die here, yes, please.
Chair Keene, I'm sorry to interrupt. I just want to be very clear for the transcript. I know you said take administrative notice and all that, but I just want a more clear statement that we are waiving post-hearing briefs.
Oh, we are indeed. Absolutely.
Sure.
Thank you for that. I appreciate that clarification very much. My omission. Thank you for that. Before we do bid sine die here, I want to thank two parties. First of all, I want to thank our IT staff for coordinating the logistics for this hearing. It came off without a hitch, so we thank you for that again. And of equal consequence to us is we want to thank Denise Haas once again, who has been gracious enough to serve as our court reporter. We're always grateful when you're able to be with us, Denise. Thank you much for that.
Thank you.
All right. Having said that, we will adjourn. Thank you all. Take care.
Thank you.